You good? Okay. Before I start, I'm just gonna say I've obviously been doing a lot of digging on this, but I also am in a position where I'm currently doing international relations, like alliance and organization dynamic research with a professor at my university. So I've read a lot on international organizations, things like the ICC, other independent organizations, jurisdiction, enforcement, blah, blah, blah. If anybody has like more niche questions or like as you're developing your cases, you have questions for me, you're welcome to reach out to me directly and ask me about it. And I'll put my email in the chat after this just because I think I might be able to help with that because it is some really confusing stuff. But so this is my topic lecture on the International Criminal Court. So we'll start off with just discussing what the ICC is and what it's grounded in. So the International Criminal Court is grounded in the Rome Statute, which is the treaty that established the ICC in the first place. It's permanent and it's a treaty-based international court. The reason that its permanence is kind of important is that it differs from some historic uses of international law in the form of tribunals and stuff like that, that in the past, the UN and other organizations have used to address atrocities such as war crimes. The ICC is permanent. It's not a tribunal. It cannot be disbanded. And the ICC has jurisdiction over the most serious crimes of concern for the international community at large. I think the biggest example is genocide, but there's a couple others, and I'll go into those later. The ICC was adopted by 160 states in July of 1998, and it went into enforcement in July of 2002. The ICC only has jurisdiction over crimes committed after 2002. So I remember somebody earlier brought up Vietnam. The ICC would not be able to do anything about any sort of action that was taken by a country before 2002. Even now, it would be a little bit strange to prosecute something that happened in the early 2000s, and I don't 100% know what the jurisdictional basis is there, but for sure the ICC cannot do anything about a crime or anything else that was committed before 2002. Just a couple past examples grounding the development of the ICC are the Nuremberg and Tokyo trials, the International Criminal Tribunal for the former Yugoslavia, and then the International Criminal Tribunal for Rwanda and the Rwandan genocide. If any of you are interested in looking into some prior examples of international criminal prosecution that grounded the development of the ICC as a permanent institution, I would especially read about those latter two tribunals. They were pretty fundamental in motivating the development of the ICC as an organization. So moving on, I wanted to touch just a little bit on universal jurisdiction and international law, especially because universal jurisdiction is something that you're probably going to hear about at least a couple times throughout this topic. Universal jurisdiction, so courts, the jurisdiction of a court essentially means the kind of crimes and the categories of people that a court is allowed to prosecute or address or handle. When it comes to criminal, it's prosecution. If it's civil courts, the jurisdiction is what kind of cases they're able to take. But universal jurisdiction essentially refers to the idea that domestic judicial systems of a state are able to investigate and prosecute certain crimes, even if they weren't committed within that state's territory by one of its nationals or against one of its nationals. The applications of universal jurisdiction aren't directly relevant to this topic, so I'm not going to go into them, but if you want to read up on it, it's pretty easy to find information about online. But what I will say is that a lot of critiques of the ICC focus on the threat of universal jurisdiction. There's kind of this rhetoric about how the ICC having like universal jurisdiction is potentially harmful because it's able to prosecute like globally. That's a misconception. The ICC does not have universal jurisdiction. I think that's an important distinction to make. It's a common critique. You'll see the terminology come up a lot, but it's important to remember the ICC does not have universal jurisdiction. It has limited jurisdiction. It can only prosecute certain types of crimes committed by states that are a party to it. So, yeah. Thomas, did you have a question?
No, sorry, I was just stretching.
You're good. And then international law is just the collection of rules governing relations between states. I'm going to be brief on this because it's obviously fairly complicated, but one interesting thing just to consider as you approach this topic, especially if you're looking at doing your AF and neg on the ICC, or even just the neg on the ICC, is just like to think about legal systems in general. When you think about legal systems in the United States or really in any other country, we kind of have to think about the enforcement mechanism, which fairly regularly is physical force. When somebody is arrested, usually it requires some form of physical force. We detain people and keep them imprisoned through a form of physical force or physical coercion. And you look at national countries' legal systems, and usually they have a pretty strong tie to some sort of police force, or at least a force that has the ability to exercise physical force as a mechanism of law enforcement or keeping people confined physically to a space so that they can face the legal repercussions associated with their actions. An important thing to remember about international law is that there is no concrete enforcement mechanism. The enforcement mechanism governing international legal decisions is significantly more complicated than it is on the domestic level, especially when it comes to state-on-state action. You have a variety of different actions that states often take to enforce legal decisions that are enforced on like one another. And so like that can be the threat of military force. It can sometimes be economic coercive measures like sanctions. And when it comes to the ICC, their entire enforcement relies on the actions of member states. And we'll get into that in a second. But that's just important to remember when you're differentiating international law from domestic legal systems. The enforcement mechanism is fundamentally different. And typically, up until very recently in the grand scheme of human history, international law was focused primarily on the relationship between states. Only recently has international law expanded to things such as the ICC, which prosecutes individuals. It's different from the UN courts because it prosecutes individuals. The ICC isn't focused on state action. It's focused on individual action. And so that's just an important thing to remember when you're kind of conceptualizing the way that this court works. And then I just wanted to do a quick aside on international law and colonialism, because I personally think that this is a very interesting caveat that a lot of people should consider not focusing a neg on, but definitely bringing up on the neg, is that traditionally there has been a very, very close relationship between normative international law and colonial tradition. International law within itself is a fairly recent concept. It kind of came in the age of globalization when we started to see the development of these larger international third-party bodies like the United Nations, like the League of Nations, et cetera, et cetera. And international law was essentially born in coincidence with colonialism in the Westphalian period. And although international law and international legal systems were fundamental in the dissolving of colonial states, in outlawing colonialism and removing colonial tradition from areas like Africa and the Middle East, there's still a very large colonial tradition in the way that international law operates. Especially when it comes to one of the biggest examples is the UN Security Council. You can look into that, but the veto power and power vested in the UN Security Council exists in very significant coincidence with Western colonial power. Same goes for like the attitudes and exploration of values and values held by international legal systems when you see that differentiation between northern and southern states. Thomas, did you have a question?
Yeah, so there we're considering, sorry if there's like a loud noise, my computer is going crazy, but um we have to consider that the US is on the Security Council. Is that correct?
Mhm.
Okay. Would that be a potential affirmation argument to say like we're on the Security Council, we can veto the decisions of this court, we should be beholden to this court?
So the UN Security Council doesn't have veto power over the decisions of the ICC. The
Oh,
UN
okay.
Security Council has veto power in other areas, but the UN Security Council has a very interesting relationship with the ICC that I'm going to get into later. It could be a good AF argument. It could also be a good neg argument. I think that there's
Got it.
a duality there insofar as if the US joined the ICC, the relationship between the UNSC and the ICC could be of like advantageous benefit to the US. On the other hand, it could kind of advance that like Western traditionalism that we're talking about, that could be seen as harmful in the neo-colonial context. Uh, Other question, Adja?
So about the colonialism argument, again, because I mostly debate in Ohio, where a lot of our judges are not progressive leaning, nor are the debaters, is there a way to run that argument in a way that seems more traditional, if that makes sense, without touching too much on progressive debate?
Yeah, so I'm not saying that it should be a progressive argument. I was 100% a trad debater. Um, what I think am pointing out about like colonialism as an argument is that I think it complements some of the more stock arguments on the ICC well, in a way that could lead to a more nuanced case. You see things like the arguments about power manipulation by more powerful states, usually Western actors, but power manipulation by more Western states targeting Africa, selective prosecution in which prosecution against Western states is avoided, et cetera, et cetera. And I think looping that in with kind of just some information or this general theme that international law within itself has had a really strong colonial tradition could potentially just bulk out that argument in a little bit of a unique way. I just wanted to point it out because I do think it's important when we're considering that like the ICC has primarily targeted Africa, and I'm going to get into that in a little bit. I have some articles on it, but um we kind of think about that, and then we think about the fact that our international legal frameworks were born from Western norms. And that within itself could factor very, very well into a structural violence argument. And so that's just why I wanted to bring it up. It's kind of a brief touch. I don't think it should be your whole case. I think running like it would get into the nitty gritty of things and gets away from kind of the core of the topic and the core clash, but I do think it could be
Mhm.
useful.
Okay,
And
thanks.
I can touch on it more at the end if needed. So I'm going to move to the next slide I have, which is this one. So ICC jurisdiction, jurisdictional basis. Before the ICC can act, the state that is being accused must be a party to the ICC treaty, or they accepted the court's jurisdiction explicitly under Article 12. So those are kind of two different things. Either they're party to the treaty or the state itself basically came out and said, like, we're opening ourselves up to ICC prosecution. The ICC is a court of last resort. We touched on that earlier. It only steps in when national authorities are failing to provide legal accountability for crimes committed by their citizens. And the ICC does tend to focus on senior officials and others responsible for crimes at a high level. Something important to think about with the court of last resort thing is that we kind of you think about selective prosecution and the patterns within the ICC prosecution. And I think that it is important on both the app and the neg to just recognize that countries with unstable governments are 10 times more likely to like, I mean, it's not 10 times, I don't know what the actual number is, but I'm saying that in like a theoretical way, they're 10 times more likely to see judicial failures. Countries that are facing governmental instability, are facing militia violence, are facing insurrection, are a lot more likely to see failures of their judicial system to hold individuals accountable for certain crimes. That within itself might account for a certain degree of the selectivity bias in the cases prosecuted by the ICC, although not the entire thing. And again, I'm going to get into that later. But I do think it's important on both sides to recognize that the ICC being a court of last resort is going to shape the way that it prosecutes, because countries with more robust, stable judicial systems are better prepared to handle issues committed by their citizens than countries that are facing governmental instability. Yeah.
Is there sometimes a bias related there? For example, like if you're like the US, even if we're not handling an issue, if we're seen to have like a more comprehensive judicial system, are we going to see less prosecution from the
I
ICC?
I would say absolutely. I mean, I don't know for sure, but from my perspective, I would say I like the ICC has never issued a warrant on the US. They've never issued a warrant on Britain. They don't really issue warrants on Western democracies at all. I have statistics on that later, but I think that it is very important to consider. It could be an AF argument, it could be a neg argument. I don't know how you want to shape it. But that the stability and robustness of the judicial system of a country, of a member state, is very likely to have a significant effect on its susceptibility to ICC prosecution. The ICC handles 4 different crimes, or 4 categories of crimes within international law. I'm not going to read the definitions out loud, but I'll share this presentation later. But it ends up being genocide, war crimes, crimes against humanity, and crimes of aggression. So just some quick facts about the ICC. The ICC since 2002 has handled 32 total cases. They've issued 59 arrest warrants with 21 people detained and 30 at large. They've come to 11 convictions and 4 acquittals. So getting into that a little bit, we'll start with the judges. The ICC is made up of 18 judges. Judges serve 9-year terms. They're elected by the Assembly of States Parties to the Rome Statute. They're not eligible for re-election after their 9-year term ends, and no 2 judges may be nationals of the same state. The court has 3 divisions which judges are sorted into. That's pretrial, trial, and appeals. And then the judges elect the president and 2 vice presidents of the court from their ranks. ICC judge composition by region is in this graph. It's actually pretty balanced. I don't know, I don't know why I expected it to be otherwise. But it's nearly perfectly balanced between the regional representation of the 18 judges, with just a few less there's 1 less judge from Eastern Europe and Asia Pacific than there is from Latin America, the African states, and Western European countries. But the current set of 18 judges is very, very balanced regionally. And then I just have a list of the countries represented by judges. There's a lot of them. Once again, there can't be 2 judges from the same state. That's an accountability mechanism. I think that if you're on the AF and you're trying to defend the ICC as a structure, that's kind of a good thing to bring up, that you can't have a party kind of a state like monopolize the ICC judge panel or put a lot of people on. Yeah, Danielle?
So if the United States were to join the ICC, would they need to, like, I guess, have a judge like represent them within the ICC, like 1 or 2 judges, or?
There's 160 countries that are party to the ICC, and there's 18 judges. So 18 countries at any given time are represented. They try to be regionally balanced. If I had to guess, if the US joined the ICC, I think the next time there was a re-election, they would get a judge on the panel of 18, but they don't have to. So moving on, does anybody have questions, overarching questions about those last couple of slides before I move on to how it works? Yeah.
This might be a little bit of an odd question, but as you stated, there were a lot of people who were still at large. So is it the ICC themselves who try and track down those people, or is that like local enforcement who tries and finds them?
No, it's not the ICC. I'm gonna get into that on these slides. So if
Okay.
you have questions about it, you can ask them after I'm
Okay.
through this set.
Perfect.
Any other questions? Yeah.
I think I would just ask back to that stat on like it was I think 21, back one more slide of the number. Yeah, 21 people detained, 30 at large. How does that fit into 59 arrest warrants? What are the remaining 8 people? Have they all passed away?
I believe so. Something along those lines.
Okay.
I took these straight off of the ICC's like
Yeah,
website.
no, I didn't know if you had.
But I know
Okay.
they did. There was a number that like passed away. And then yeah, I believe you're right. I think it's eight people who have since been
Got it.
yeah. It's like on their like main page though. Like if you look up like ICC number of cases, you'll be able to find the stats. So yeah, moving on to how it works. The ICC begins with an investigation. So this is very important. This left-hand category, I think that it's a little bit nuanced, but I think that it's going to end up being very important to a lot of arguments. The ICC can only open an investigation in 3 different ways. Either a member state comes to the ICC and refers an issue, so says to the prosecutor, like, there's a problem happening in another ICC member country, like in a country that is subject to ICC jurisdiction, please address this. The UN Security Council can refer the ICC to a situation existing anywhere in the world. or with the approval of pretrial judges, the prosecutor can launch an investigation into a situation on their own initiative, meaning that the ICC within itself initiates an investigation. The first two, member state referrals and the UN Security Council referral, are the two primary ways that the ICC receives cases. I believe they have only used their own initiative or this third mechanism. I want to say like 1 or 2 times. It hasn't happened very many times. Yeah, Ria?
So on the member state referral, so how does that happen? Like, just does a regular civilian be like, oh, this guy is doing something wrong, like we gotta lock him up?
No, it would probably be whoever, so like it would somehow move they're usually very high profile crimes. And so it would be brought to the attention of whoever is representing the country that's party to the ICC. On that, it's like the ASP, I forget what the exact wording of it was, but it's the group of countries that are party to the Rome Statute. There are representatives that like will represent a country, or like maybe it's their Department of State head, something along those lines, but there's probably a government official that is responsible for representing that country whenever the like Rome Convention meets, or whenever the group of party states to the ICC meets.
What would happen if like that person who's supposed to be representing them like is corrupt and like they're the ones who are doing the crimes?
Well,
Okay.
that's a good point. Again, I think that those are some of they're loopholes that you can poke. Those are good things to point out. But the way that this works is that it's not a country refers itself. It's a country in the ICC can refer any other country that's party to the Rome Statute. And so if there's like a corrupt official in Uganda and an official from Kenya refers that situation to the ICC, given that both of those countries are under ICC jurisdiction, the ICC then can open an investigation. But I do think that it is very important to recognize on this side that the large majority, almost all of the ICC's cases, have been initiated through member state referrals and UN Security Council referrals. So you're going to face neg arguments sometimes that refer to selective prosecution. Now, there certainly are still very solid selective prosecution arguments, but it's not the ICC within itself that usually opens investigations in the first place. And so it's important to recognize that like the jurisdictional mechanism there and the mechanism of finding and accepting cases is a lot more complicated than the ICC within itself just being unjust and saying like, hey, we're going to prosecute that country, or we're going to prosecute that country. And then the court can investigate individuals from non-member states if the alleged offenses took place in a member state's territory, if the non-member state accepts the court's jurisdiction, or with the UN Security Council's authorization. So look to countries like Russia and Israel, where there's currently warrants out for the arrest of, example, Vladimir Putin, but there's a handful of others. Neither of those countries are party to the ICC, but they were subject to authorization under the UN Security Council that gave the ICC the ability to issue those warrants. Yeah, Thomas?
Yeah, from the perspective of like a potential negation argument, you can only arrest people when they enter ICC jurisdiction, right? Even if you have warrants out for them outside of ICC jurisdiction.
Yeah.
Okay.
Danielle?
So I'm still a bit like confused on the UN Security Council and like the referral and everything. So isn't the United States like a part of the UN Security Council? Okay, so can't they like already refer a situation that occurs?
It would have to be the whole council. It can't just be the United States, but yes. Essentially what would happen is, I mean, the US was, I believe, played a role in the referral that like gave the ICC jurisdiction to search out a warrant on Putin and target Russian officials. But it's not just the United States that that is responsible for that.
So, like, say hypothetically, if like the UN Security Council, for example, human rights violations, say they were happening somewhere, and that's like what the ICC accounts for, then couldn't they just like basically like handle that without the US becoming parties to the ICC, if you know what I'm saying. I don't know. I'm just still a bit confused.
Yeah, so essentially what I am trying to get at here is that the mechanism by which the ICC receives cases is fairly complicated. The UN Security Council is able to refer a situation to the ICC, which the ICC then can open an investigation on. That's not just the United States, it's the entire Security Council. I don't know exactly what majority is needed. I'm sure that's easily findable online, but yes, the US could potentially, I suppose, exert influence on ICC activities through the UN Security Council, but also it's worth noting that the UN Security Council authorized the warrants for high-ranking officials in Israel, which was an action that the United States absolutely didn't agree with as a prominent Israeli ally. And so the whole mechanism within itself is pretty complicated. I would urge all of you to read up on it more, but I'm just trying to give kind of a base understanding about how that kind of works.
Okay, thank you.
And then the pretrial procedure, to open an investigation, the prosecutor has to conduct a preliminary examination and conclude that the alleged crimes are of sufficient gravity. Once an investigation is open to the prosecutor's office, they'll send staff to collect evidence. Any arrest warrants or summons must be approved by the judiciary. So evidence collection is handled by ICC staff, but the enforcement of arrest warrants or detention of actual physical individuals is reliant on the actual governments of the countries. So like they rely on states to enforce their will. The ICC will issue a warrant and then a state has to go in and physically arrest the person, which is one of the main reasons that there's doubts shed on the efficacy of ICC enforcement. And then a group of pretrial judges will confirm whether the case should be brought to trial. Defendants can seek outside counsel for representation, and if they can't pay for it, the court will. And then convictions require a minimum of 2 out of 3 votes from the judges on a 3-judge bench. So, is this? Yeah, wait. Yes, okay. ICC cases and indictments. I just wanted to give some quick statistics. These were not linked from a source. I wish I could send them to you, but I can't because what I ended up doing was just digging through the ICC's website and looking at each individual case that they had open and where it had initiated. So these numbers are accurate if you want to use them, or if you want me to send you the like actual numbers. I couldn't find them on like line. Nobody had done it for me, so I just did it myself. But case composition by country. All 32 open cases that the ICC, or not 32 open cases, but all 32 actual cases that the ICC has handled have been focused on African countries. So we've got Rwanda, Uganda, Côte d'Ivoire. The largest ones were the DRC, Sudan, Kenya, and Central Africa. So that's kind of worth noting, but the actual cases are different from indictments. The indictments are kind of the initial step taken towards opening a case. Cases are things that actually started to get into the trial process. The current ICC prosecutor is a British barrister and lawyer, so that's worth noting. The current head prosecutor of the ICC is from a Western country. And then indictment statistics also largely are from African states, but more recently, the ICC has also issued some indictments in Eastern Europe. Largely focused in Georgia and, or what is now Georgia, and then Russia, and then in the Middle East in Israel. So the ICC relies on the cooperation of member states in order to enforce its procedures. Apprehension and arrest of suspects is handled by the member state, and the ICC doesn't have a police force or other physical enforcement agency to handle detention. So I just wanted to touch briefly. I'm not actually going to read through all of this, but I would urge all of you to look at it. On the question of whether the ICC is targeting Africa, it's a pretty complicated question. Obviously from this, you can kind of see that the large majority, I mean, all of the cases and the large majority of indictments were focused on African states. But whether or not that was actually improper targeting is debated by scholars. So I've linked 3 different articles here. This first one kind of examines the relationship between the ICC and Africa, concluding that it's fairly oversimplified and that there is present selectivity bias, but that the selectivity bias that is present is kind of misconstrued sometimes. Basically, what this first article said is that the prosecution of cases in the African continent by the ICC has not been improper. What is improper is that the ICC has failed to prosecute other cases. So the issue isn't with the cases that the ICC addresses, it's with the cases that the ICC chooses not to. This second article basically concludes that the ICC's focus on Africa is not legally or morally inappropriate, but that it does threaten to undermine the perception of the court's fairness and legitimacy. If this is an argument that anybody wants to kind of dive into, I would absolutely support that. I think that judicial legitimacy it's a very interesting issue. And I think that it would be a very, very interesting angle to take as part of a neg case, that essentially it doesn't really matter if the ICC has engaged in misconduct in Africa. What matters is that the ICC's disproportionate handling of cases in the African continent has undermined the perception of the ICC as a legitimate institution across Africa, the Middle East, and many, many developing countries. And so that within itself causes the ICC to be less effective in enforcing things or in operating as a legitimate institution, or kind of in that sense. Yeah, Thomas?
I think a couple of people had their hands raised before me, so if they want to go,
Yeah.
they can. Otherwise, I can take it.
Just
Namely,
go.
Danielle and Adja.
I think you had your hand up first.
Oh,
Oh,
okay then.
thanks, Thomas. I just wanted to ask about the actual solvency, and I know this is more that something was mentioned in the progressive um part of today's camp, but when we're discussing about the ICC's focus in Africa, I know that the ICC is supposed to be a last resort. So are they doing anything to help other domestic like legal courts be established before the ICC comes in? Because I know we were talking, and one of the articles that were found in the research during the break was is that it could increase domestic judicial support by having the ICC, or by the United States having the ICC. So do we see that in Africa, or is that something that's still lacking?
So I think the point in that article, at least the way that it was described, is that the United States itself already has a robust and pretty stable judicial system. We don't want to face ICC prosecution, so if we were party to the ICC, it might encourage us to handle issues quicker and better on a domestic level so that we don't have to deal with ICC intervention. In a lot of
Okay.
countries in Africa, especially you look at places like the DRC that has faced a lot of prosecution, they are facing incredibly high levels of governmental instability, insurgent by militia groups, um, takeovers, et cetera, et cetera. That within itself undermines judicial legitimacy on the domestic level. The ICC doesn't do anything formally to develop domestic courts. But I think that in Western countries, it's probably very likely that being party to the ICC increases oversight, judicial oversight on the domestic level, at least a little bit. I don't think that we've seen a trend like that in developing nations.
Just like a
Um,
follow question on that. Sorry, I know that there are other people after me, but wouldn't there be a counter argument then by the affirmative that could be stated that by having the United States be a part of the ICC, then at least we'll be able to have some sort of check or something to be able to help this? Or that this is non-unique because this would occur whether the United States is or isn't a part of the ICC?
I think that the non-uniqueness argument is good. I don't think that I don't see what the check would be. The Again, it's because the cases happen through referral processes. And again, two of these articles touch on that. But the idea that the US is targeting, I mean, that the ICC is targeting Africa is oftentimes largely grounded in a misrepresentation of the referral process. I would
Oh,
read
okay.
the articles. They give a lot more information than I can, but I am running out of time, and I think I have like 10 more slides. So, Danielle.
Okay, I'll go super quick. Specifically on how you talked about how the ICC's focus on Africa threatens to undermine the perception, and it like kind of compromises the court's fairness and legitimacy and like justice. How specifically could we connect that to the United States? And also, how would you respond to if someone said it was non-unique?
So I think what I would say is that again, these are more principled arguments. That's what I would run on the ICC. I know that it's been said like by a couple people that that doesn't work quite as well in Ohio. Um, and I don't think that this is an issue with solvency. The United States joining or not joining the ICC isn't going to fix the structural issues within the ICC. I think the specific argument here would be that there is no tangible benefit for the United States to take positive action and join a illegitimate institution. If the ICC has effectively undermined its own legitimacy through selective prosecution in Africa and of developing countries, the United States joining the ICC has no public relations benefit and may instead kind of have a public relations detriment insofar as the United States is choosing to join an institution that is complicit in like targeting this certain region. Again, what I will say is all three of these articles essentially conclude that the targeting of Africa and the prosecution of Africa was not morally or legally illegitimate on behalf of the ICC, but that the ICC, by doing that and not picking up or doing other cases along with the prosecution in Africa, has kind of created this perception that they are targeting African states. The issue is not with the actual cases that were handled in Africa. Most of them were handled well. It just comes down to the appearance of that action. Thomas, did you still have a question?
You answered my question. It was essentially like, would us joining be a PR nightmare amongst smaller nations?
Yeah. And then this last article, I'm not gonna like super go into it. I don't really agree with it. I wasn't a huge fan of it, but I put it on here because I think it's an interesting block and maybe some of you will disagree with me. I think part of my issue with it was the author's tone, and I just think it came across as like a little bit aggressive, and that made me kind of doubt the legitimacy of the argument that was being made. But essentially, this author argues that the political rhetoric that the ICC is targeting Africa is manipulative political rhetoric advanced by states in the African Union, and that it's essentially trying to absolve Africa from facing responsibility for actions, or certain African countries from facing responsibility for actions in the future by calling out selective prosecution now. So I wasn't a huge fan of this article, but I did decide to put it in there just because I do think that it's an interesting take. It is a scholarly article. It was published in a reputable journal. And so I do think it's an interesting take if any of you kind of want to look into that. But I would really lean towards these first two articles. I think that both of them are very good. They're long, but I would read them in full. I think that it gives a very good angle on this issue, and it's going to allow all of you as debaters to approach this in a much more nuanced way than a lot of your competitors. So my next thing is on the trial and conviction. The trial procedure. Trials in the ICC are heard by a panel of 3 judges. The burden of proof is on the prosecution. And the prosecution must prove that the accused is guilty beyond a reasonable doubt. In the US legal system, we have 3 levels of burden of proof. It is by a preponderance of the evidence, which is more likely than not. There's clear and convincing, which is one step up from that. And then you've got beyond a reasonable doubt. That's the standard that we domestically use in criminal trials. And essentially what beyond a reasonable doubt, if any of you end up going into law, you're going to hear a lot about reasonability, but it essentially means that your average sane, logical, reasonable person, if they were to see that there is a doubt with the case presented by the prosecution, they can't find that person guilty. And so the prosecution has to prove their case to the extent that there is no existing reasonable doubts. That is the same standard that the ICC uses for a conviction. Judges consider all evidence and then issue a verdict. When there's a verdict of guilt, the judges issues a sentence. Usually that's up to 30 years. In exceptional cases, it can be life. Judges can also order reparations for the victim, and then both the prosecutor and the defense have the right to appeal a verdict of the trial court and or order for reparations. An appeal is decided by a panel of 5 judges in the appeals chamber who are never the same judges who gave the initial verdict. In an appeal, the panel of 5 judges can either choose to uphold the trial court's decision, amend it, meaning they'll change it, reverse it, meaning they'll say, yeah, you were wrong, we're turning that around, or they can order for a retrial insofar as there was either some sort of mistake or some sort of evidence wasn't disclosed, or they can then kind of turn that back around, push it back down to the trial court and say, you need to do this again. Yes, Thomas?
Where do they serve prison time?
They serve prison time. The ICC is very vague about it, but it's in countries that are party to the ICC, to the Rome Statute, that agree to hold prisoners within their borders, whatever that means. Ria?
Wait, isn't it Hague, Netherlands? I think
Um,
it's something like
Hague
that.
is where the detention center is, so that's before the trial happens. When they're leading up to trial and they're in the pretrial process, prisoners are held in the detention center in Hague, but if they are convicted, they're moved elsewhere. Yeah, Azzy?
Yeah, so my question was, a popular neg argument is that the ICC is like a really soft court, and my coach says that they never give like death sentences or like prison for life sentences for a very long time. So somebody could kill like a couple hundred children and they could only be sentenced to prison for like 10 years in like a European prison. And that's not like their proper due as to compared if they were prosecuted under a United States judicial system properly. So what would you say if like all of the rulings are like essentially really soft and they don't actually have like an impact?
So I think I have kind of two things on that. I think that the death penalty in the ICC just doesn't need to get stepped into. There is literally no reason that an international court system should ever be able to issue a death sentence. I think that that's just part of the jurisdictional basis there, is that the ICC isn't a state. People don't sign on to its constitution. You're not a citizen to the world order. And so for the ICC to be able to issue a death sentence, I think that the response to that is that that would just be way too far. In terms of prison sentence, I do agree with you, and I think your coach is probably right. The ICC, I think, sometimes does issue verdicts that are a little bit soft on that front. My response to that as a like debater, or I think what you might face if you bring that up and round, is that the ICC is trying to, it's the idea of complementarity. The ICC is trying to be a complement to domestic legal systems. To exert overly harsh sentences, multiple life sentences, forms of punitive punishment outside of imprisonment in which individuals are granted human dignity and human rights, I think it would very, very far outstep the bounds of what the ICC is supposed to do as a court of last resort. The ICC, I think, tries its best to not overstep boundaries or directly contradict domestic legal systems. And I do think you're right that if a lot of people that have been tried by the ICC were tried in the US, they would face a much more punitive sentence. But there's a reason that they're not being tried in the US, and it's because they're not US citizens. And so I think that I don't know, it's complicated, but I would say that I think that the argument maybe has some merits if you're going to run like a full inefficacy case, but I wouldn't make that your hill to die on.
Yeah, and then the second thing that's really popular and going around is that the ICC is unconstitutional and like it doesn't give people like the rights that were issued in like the Bill of Rights. So if the United States became subject to the ICC, there might be unfair trials according to US law. Like apparently there's a card saying people could wait in prison for up to 5 years before their trial begins. Because even if it says to be tried without undue delay, there aren't like specifications on how this can be ensured or like how long people can wait or what specific rights people are going to get that we have in our amendments. So what the negative wouldn't want is people in the United States being subject to a court that violates their rights as a US citizen.
I think that's definitely a valid neg. I'll go through the rights. I think that's up to everybody's interpretation. I mean, people sit for a long time without trial in the United States too. Our judicial system is not the most effective thing ever. I think that if you're going to make constitutionality arguments or arguments that compare our domestic legal system to the legal system of the ICC, it's just very important to pick out what you want your hills to die on to be, because there's a lot of inadequacies with the United States legal system. There's a lot of inadequacies with our Constitution. There's a lot of inadequacies with the way that we handle trial and evidence and justice. And I just think that it's very, very important to make sure for everybody here that if you are doing a constitutionality or inadequacy argument, you are focusing on things that actually are different between the ICC and US courts. I just listed the rights here. I actually found these pretty interesting. I hadn't looked at them before, but they're pretty similar in a lot of ways to the rights that we provide individuals in US court systems for criminal trials. The right to counsel, the right to be informed of charges in a language that they speak. It's a pretty common thing in civil and criminal due process that the right to be heard and the right to trial is not, it's without merit if it's not tailored to the circumstances of the individual that is meant to be heard. And I think that the ICC does a good job of that, at least in their rights provisions, and ensuring that individuals are informed of their rights, the procedures, the charges that they're facing, in a language in a way that they're fully capable of understanding. Individuals have adequate time and facilities to prepare a defense. They have the right to be tried without undue delay. They have the right against self-incrimination that's vested in the U.S. Fifth Amendment. And then they also have the right to disclosure of any sort of exculpatory evidence or evidence that is used by the prosecution that could show innocence, mitigate guilt, or affect the credibility of the prosecution's evidence. And that's also a standard in the U.S. legal system. I forget what the case is, but yeah, so prosecution disclosure of exculpatory evidence is also standard in the ICC. So I think that I just thought that was pretty interesting. I don't know what you would actually do with that, but the rights provided to suspects in international court procedures are fairly mirrored to a lot of US provisions. There's obviously more provisions, I think, in the US legal system and a lot more caveats, but they do reflect Western systems pretty well. Oh, I accidentally duplicated that slide. We're going to ignore that. The US and the ICC, I'll keep brief on this because I think I'm running out of time. But this is just a quick timeline. Pre-1998 is when US policymakers helped draft the concept of the ICC. Clinton administration participated intensely in the UN negotiations over the Rome Statute. In 1998, when it was ratified, the US opposed it. In 2002, President Bush signed an act that cut off financial assistance to ICC members who had agreed to surrender US personnel to ICC. President authorized use by all means necessary to free Americans detained by the ICC. The ICC has never detained any Americans, so we never actually had to do anything about that, but it did happen. US and ICC collaboration in 2005 and 2011, we saw some collaboration between the US and the ICC. The Trump administration took a much more strict stance, really did not like the ICC. And then under the Biden administration, he kind of returned back towards that mildly cooperative state. And then I'm assuming as we're going back into a new Trump administration, we're going to go back to being pretty animus towards them. But to date, the ICC has never issued an arrest warrant for any US official. Common arguments in favor of the ICC. I think that there's 5. It's accountability. So the ICC serves as an accountability mechanism for perpetrators of severe crimes that might evade justice otherwise. It's one of the few legal systems capable of holding leaders and high-ranking officials criminally accountable. Another one is deterrence. I don't know that this is a very good argument. I wouldn't argue deterrence on the AF if I was any of you, but it's an argument that can be made. Complementarity. The ICC is intentionally structured to complement existing legal frameworks on the national level. It creates an accountability mechanism only where domestic governments fail. So it's a fail-safe measure. Promotion of global justice. ICC serves as a symbol of the international community's commitment to upholding human rights and has aided in establishing and strengthening norms of international law. Cooperation and unity. It fosters global cooperation between member states and promotes long-term peace and stability in post-conflict societies. And then common critiques. Political manipulation can be used as a tool of political manipulation by states with a larger degree of power. Powerful states can leverage the ICC to target or burden weaker states or rivals. Inefficacy and limited success. Since 2002, the ICC has had few convictions, 11 total. Despite significant financial and administrative resources, it relies on member states to enforce warrants. There's no enforcement mechanism intrinsic to the organization. Challenges to sovereignty. Undermines national sovereignty by intervening in domestic legal matters, especially pertinent when the ICC handles cases that domestic courts are unwilling to prosecute. And so failure doesn't just have to be that a country can't prosecute, it can also be that a country refuses to prosecute. Bias and inconsistency has been perceived as disproportionately targeting African nations, and it appears to be selective in the cases it chooses to investigate. And then there's jurisdictional contests regarding the conflict between national court systems or other international tribunals and the jurisdiction of the ICC. And then that takes us to the resolution. So that's kind of all I have. If there's like any outstanding questions by people or comments or things, I'm happy to handle those before we have a quick break.